Civil Law Committee will come to order. Quorum remains in place from this morning. First bill up, Representative Sawatzky, House File 2568. Representative Sawatzky, Chair, moves to re-refer House File 2568 to Committee on Education Finance. This committee's jurisdictions is over the data provisions in Section 1, Subdivision 2. There's an author's amendment labeled A4. All in favor of getting the bill in the shape the author desires by passing the A4 amendment signify by saying aye. Aye. All opposed say no. Motion passes. Thank you. Representative Sawatzky, to your bill as amended.
Thank you, Mr. Chair and Committee. There's also one other oral amendment that we found on line 3.20, a typo. And the acronym for the MARS system, M-A-R-R-S, should be M-A-R-S-S.
Say that line again, Representative Sawatzky.
3.20.
Okay. So, is that within the parameters of the amendment, or can we just amend the bill as stated? The bill as amended, we can amend it again, right? Okay. So, Representative Chair moves that the MARRS acronym on line 3.20 be stricken and replaced by MARSS. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Okay, go ahead, Representative Sawatzky.
Thank you very much. I'm Mary Sawatzky, and thank you for hearing House File 2568. This is the first time in front of your committee, and I would like to welcome you to Pi Day, thus my superpower shirt. If you can see the pi symbol in there, work on it. Some people can, some can't.
Mr. Chair. Thank you. I figured that Pi Day meant you brought us all pie.
That's true.
One strike against me, give me two more.
We'll keep that in mind when the vote comes.
All right, thanks. I'd like to thank Representative Scott and Representative Holberg for helping me along with the data privacy regarding this technology and our most vulnerable students. I am very aware of the Family Education Rights and Privacy Act, as this has been my career as a special education teacher for the past 29 years. With that said, this bill is a step towards streamlining special education paperwork, creating a statewide online system, allowing more face-to-face teacher time with their students. In a survey from Education Minnesota, which over 1,000 teachers, past and present special education teachers responded, 73% supported a statewide online system. With that support, school districts and co-ops must uphold the integrity of the special education due process, and with your help and the stakeholders who are advocating for our students, I want the best bill to pass through this legislative body. This system will allow all Minnesota schools to use one consistent format. Parents will have consistency in reading and understanding the various forms as students move around the state. Student teachers will be well prepared as they enter any Minnesota teaching assignment for their student teaching assignment. And it will reduce privacy concerns with faxing documents and reduce U.S. mail wait times for records from one school district to another. So for the purposes of this committee, please refer to the data privacy piece. And as background information, most Minnesota schools use some form of an online system right now with vendors for the special education due process on a local or on a district level. And that includes parent forms, signatures, the IEP, the evaluations, and progress reporting. However, these independent systems do not presently interface with any centralized repository, and with that, this is why we would like a statewide online system. And I would welcome any questions that you might have.
Questions from members? Representative Holberg.
Thank you, Mr. Chair. And first of all, Representative Sawatzky, I think, contacted me a couple days ago. Well, by the time we're at Friday and at this pace, I can't be exactly sure. And I haven't had the time to really go over this finally. I would just like to make a couple points. She's been very open to working on this, and I just hope that maybe we can move this out with the idea that if we can do a little fine-tuning before it gets to the floor, I would hope we'd be able to work on that. And one of these, the issues as I look at this is in the, on the auditing function that they may, I would think that you would want a must for compliance reporting, not a permissive, but requiring it. in your consulting with qualified experts, et cetera, I think that you should probably have some privacy experts or whatever. And then my intent is that you would have a system where parents would have control over who would have access to their student records, and so that there wouldn't be one blanket form that you'd sign the first time you had an IEP and then never again know who was having access to the records. And I think the system should also be required to have an audit trail, so that if a parent wanted to know who had access to their students' records, that information would be readily available to them. So those would be some of the issues that I'd try and get some better language in the bill as it moves forward.
Representative Sawatzky, are you willing to work with Representative Holberg
I would-
to progress from here?
100%, and I thank you for those concerns. And I think, to tell you the truth, to have that audit trail online would be much better than the existing system that we have right now. And so I would 100% guarantee that I agree with you.
Thank you, Representative Sawatzky. Other questions from members? Seeing none, then the chair renews the motion that House File, as amended, 20, say again? House File 2568, as amended, be recommended to be re-referred to the Committee on Education and Finance. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you, Representative Sawatzky.
Thank you.
Representative Johnson.
Mr. Chair, Representative Sawatzky, I just have one question for you.
Yes.
If
Sawatzky.
you should happen to bring pie to our committee the next time you come here, make sure you bring it from the city of Bremen, my district, which is the pie capital of Minnesota.
I take exception to that.
I think Representative Johnson speaks for all of us, Representative Sawatzky. Next bill, Representative Moran.
Did you call Johnson? Oh, I'm sorry.
Well, now that you're down here, Representative Johnson, we might as well take care of you, because I don't see Representative Moran. Is that right? Representative Moran's not here? So, Representative Johnson, come on down, have a seat, and Representative Johnson, Chair moves that House File 2295 be referred to Committee on Judiciary, Finance, and Policy. There is an author's amendment labeled A1 in order to get the bill in the shape that Representative Johnson C desires. All in favor signify by saying aye. Aye. All opposed say no.
Mr. Chair, it's not in my packet unless it was loose.
Yeah, we just adopted an amendment we don't have.
I don't
Well,
see it.
Representative Holberg moves reconsideration of the A1 amendment. All in favor say aye. Aye. All opposed say no. So let's make sure we have that. What happened? Meanwhile, while it's being retrieved, Representative Johnson, why don't you explain what the amendment does?
The amendment on line 15, after victim, insert and defendant, and on page 3, line 16, that first one is on page 2, on page 3, line 16, after victim, insert and defendant. And that was to assure that the data privacy relates to both the victim and the defendant.
So we could probably do that orally without having an A1 amendment. Is that right?
Well,
Mr. Gehring, is that doable?
there's one more. On page 1, line 4, after victim, insert and defendant.
Okay. Well, we'll do that orally, but now I lost my CA to go find it. So why don't Representative Johnson, you go through the bill and tell us what you're trying to do.
Okay. Thank you, Mr. Chair. It's out of the concern about the safety of victims of domestic violence that I ask for your support for House File 2295 as amended. Last year, 37 Minnesotans lost their lives as a result of domestic violence. 2 of those people lived in my legislative district. In 2011, Minnesota district courts handled 27,288 domestic violence cases. and in 2010 there were 929 victims of a violation of an order for protection or harassment restraining order. This bill will offer protection to victims of domestic abuse through GPS monitoring. It builds on a successful pilot project in Ramsey County. This bill will allow that project to continue. It will also allow other judicial districts to convene an advisory group to establish standards to implement similar programs. The group must be comprised of important stakeholders, including crime victim organizations. You can see that in lines 3.1 to 3.4. The bill establishes minimum state standards that must be met in any judicial district, lines 3.5 through lines I might have my lines wrong there. I got it. My note is incorrect. Hold on. Lines 3.5 through 3.15. And I just want to mention that before I introduce Mr. Choi, who is the director of the current project in Ramsey County, I want to acknowledge a local interest in this, and that is that I've been working with Pat McDermott, the assistant Blue Earth County attorney, on this, and he's not here today. There's a lot of work being done in Blue Earth County on another case, and but it really he does strongly support the bill, and Blue Earth County has successfully used GPS in unrelated in other types of cases, and the county also has a great deal of experience working with criminal justice professionals and community groups and specialty courts. He informed me that if the bill passes, he indicated that he will ask Judge Bradley Walker, Chief Judge of the 5th Judicial District, to appoint and convene an advisory group to develop standards in the 5th Judicial District. And then the last note is that today the Mankato Free Press in its editorial tried to get a copy to you today. I didn't manage. Did clearly express support for this bill and for GPS monitoring of domestic violence offenders, in recognition of the significant problem that we are experiencing in our area, and I think it's safe to say throughout the state of Minnesota. So I'll let Mr. Choi explain the Ramsey County pilot project.
Thank you, Representative Johnson. Mr. Choi, welcome to the committee. Please introduce yourself for the record.
Thank you, Mr. Chairman and members of the committee. My name is John Choi. I'm the Ramsey County attorney, and I'm really pleased to be here in support of House File 2295, and I want to thank Representative Clark Johnson for bringing this issue forward, because from Ramsey County's perspective, this legislation is critical because we would like to continue with the pilot project that we have started back in November of 2012. We started this pilot project under the authority that the legislature gave to us, allowing for these demonstration pilot projects to be started to use GPS technology in domestic violence cases. And as all of you know, when we have a domestic violence incident, these situations are oftentimes unpredictable and very volatile. And so when we have a first appearance, typically a judge will issue a domestic abuse no contact order, ordering the accused, the defendant, to stay away and not contact the victim. That's typically customary practice, but at the end of the day, if you think about it, that no contact order is just a piece of paper. And given the advances that we have had in GPS technology, the legislature, in its wisdom back in 2010, decided that it would be good to take a look at utilizing GPS technology to keep victims safe. And ultimately, when we look at these situations in Ramsey County and throughout the state, we should be looking at them as potentially homicide prevention, that we should be doing everything that we can to keep victims safe. And so the program in Ramsey County that we started back in November of 2012 focuses on those pretrial situations when someone has been arrested and accused of domestic violence. And we only do this when the victim asks for this technology. And if you think about it, a victim who asks for GPS monitoring is probably very fearful for their life or their safety. And so in those instances where the victim asks, and we have a certain criteria that we use, and we're looking for, obviously, if someone is a high risk and has had repeated domestic violence incidences, we'll be asking the judge for high bail. We would like them to stay in jail pending the outcome of their case. But the reality is for low-level risk and intermediate risk, a lot of these individuals are going to bail out. And so we have to recognize that, and we have to recognize that the fact that if there's a victim out there who really fears for her safety and her life, then this GPS technology can be a great benefit. And so we have implemented this program, and we've had limited experience. We haven't had a lot of individuals on this program. We've capped it at no more than 5 at a time, and overall I think there have been about 27 people that have gone through this program. But the preliminary results are promising, because what we have found is that the experience shows, and this is consistent with the research that exists throughout the country, that with respect to adhering to the terms and conditions of the order, so appearing at the next court appearance, and then also with respect to recidivism, whether or not there's a subsequent violation, we have found that this technology, actually the people that are on this technology will comply much better than people who are not. And so that's one of the reasons why we'd like to continue this, and we'd like to build more experience so that we can report more information back to the policy makers here at the legislature to see if this is a worthwhile investment. But right now, at this point, we believe that it's certainly promising and that we should be able to continue this pilot project.
Thank you for your testimony, Mr. Choi. Questions from the committee for County Attorney Choi or Representative Johnson? Representative Holberg?
Thank you. Mr. Chair, and I don't know if your amendment, if you also need to insert "and defendant" after the word victim on page 3, line 6. But the working group that you have put together, you don't have anybody on that working group that would maybe be like an ACLU or a privacy expert kind of type? You might want to consider that. And I just want to pose a question for you in that, say if I myself am a victim, I'm a total privacy freak, you're going to put some kind of monitoring device that's going to record my location for my safety. Quite frankly, the security data provision that would still allow law enforcement or others access for other purposes would not be enough for me. So I think you really need to look at a retention schedule and a very limited access, because it's a matter of trying to address public safety, but I really don't want anybody to know about my day-to-day activities outside of the goal of where I am in relationship to somebody who may be threatening my safety. And so I'm not quite sure that there's enough in here to really finitely describe how that data can be used just for this purpose and not subject people to a Sophie's choice. And I want this protection, but I really don't want law enforcement to have my location data for other purposes for an extended period of time.
Representative Johnson or Mr. Choi, first question being, do we need to add "and defendant" after victim on line 3.6? Was that just missed in the A1 amendment? And then second, if you can address Representative Holberg's other query.
Yeah, I'm comfortable with adding "and defendant" on line 3.6 after victim.
So
The nature of the
Representative Johnson.
I'm sorry, Mr. Chair. The nature of this is there, as you can see, there's choice involved by both the defendant and the victim, and so that would make sense.
Mr. Chair.
Representative Liebling.
I think, sorry to interrupt, I'm confused by what the amendment is trying to do, and somebody's mentioning 3.6, but that's not in the amendment. The amendment is line 16, not line 6. So do we need it both places?
So here's the story, Representative Liebling. The A1 amendment adds "and defendant" after victim in all locations in the bill where the word victim is used, referring to it in that same manner. One that was left out and pointed out by Representative Holberg is line 3.6. So the question was that missed in the A1 amendment? Should line 3.6 also be added in the A1 amendment?
All right,
That's why
thank
we did
you,
it.
thank you.
Okay, so all in favor of amending the A1 amendment by adding line 1.6 and stating page 3, line 6, after victim, insert, and defendant. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. So, to the A1 amendment as amended, all in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you. So it has been amended. The A1 amendment is included in the bill. Now, Representative Johnson, if you want to address Representative Holberg's other concern.
Mr. Chair, I'll ask Attorney Choi to respond to that.
Mr. Choi.
Yeah, Mr. Chair and Representative Holberg, I think what you said is well received and well stated. I think those are concerns that we should probably work on and think through. But I want to say, first of all, though, that I know you described it as a Sophie's choice, but it truly is. We won't be asking this. We don't ask for this GPS technology unless the victim wants it, right? And so there's that aspect of just having this being a voluntary program. And then secondly, you raised the question and the issue about retention schedules. And ultimately, I think that it would probably be beneficial for the legislature as the policymaking body to probably put into this bill about what you think the retention schedule should be, and I would suggest that it should be consistent with everything else that you're doing with respect to GPS monitoring. I know there's a lot of bills that are floating around the legislature that talks about security information and retention schedules. Ultimately, I think the legislature should think about that and put that into this bill, and I think we could be fine with that. I think the only thing that I would want to see is to make sure that there's a little bit of time after the resolution of the case that some of that data could be maintained by the provider, whatever you believe is reasonable. And then we will, in Ramsey County, we'll work with our vendors to make sure that their retention schedule as it relates to this will match whatever the legislature wants it to be. But I also want to mention that there's obviously public safety issues, and I know that you will be thoughtful as you think through the balancing of the privacy and the public safety issues as well.
Representative Holberg.
Mr. Chair, I'm not familiar with how these things work, and I understand that it would be voluntary by the victim, but I can tell you as one individual put in that situation, it would be a very difficult choice for me if I knew that all of my whereabouts as were being recorded and stored when I did nothing wrong. And so if you are a victim, what type of data is stored, collected and stored on your whereabouts as you are wearing this system?
Mr. Choi.
Mr. Chair and Representative Holberg, the technology that we use in Ramsey County is, I would describe as the Cadillac version. So basically, the victim would have a device, as would the accused. And so there's two devices. One's an ankle bracelet for the accused. The other one is just a kind of a little box that looks like a cell phone. And GPS information would be recorded on both because we need those coordinates to ensure that the person with the ankle bracelet is nowhere near the person who is fearful for their safety or for their life.
And if I might, on the cell phone-like device that the victim has, does that store location in real time, or does it only make note if there's a proximity, like a ping type of activity?
Mr. Chair, Representative Holberg, it's in real time.
And I'm sorry, I bet you were glad I was gone all morning, huh?
It went a lot faster.
I'm sure it did. I'm sorry. Is there a way with these devices to not collect the real-time location data outside of if there's an interaction with the defendant?
Mr. Choi.
think it would be, Mr. Chair and Representative Holberg, I think you have to have both in order for the technology to work, because it's all about keeping the person with the ankle bracelet away from, yeah.
No, I understand that, but, so in other words, if there was no interaction between the two devices, say for 48 hours, could that data be dumped on the victim as to where they were? In other words, a very short retention schedule for the victim's whereabouts, so that they wouldn't have that dilemma of feeling like they were being tracked every day just because they were a victim.
Mr. Choi?
Mr. Chair and Representative Holberg, I think you're raising some really technical issues that relate to the technology, and I'm not sure that I don't want to give you false information, so maybe it would be best to get back to you on that particular point, to have the vendor maybe ask you. But I also want to note that this technology has also, as a part of the justice system, it's actually exonerated individuals too. There was one particular case that came to law enforcement's attention after an incident, and they utilized GPS technology to recognize that the person who was accusing the other person of violating the conditions of the no contact order was nowhere near this particular individual, and therefore that person was not charged with the crime.
I understand that, but I just have a strong aversion to people who have done nothing wrong having their location and information about their personal life stored by government and to be used for who knows what purposes beyond what it was originally collected.
Any other questions from members of the committee? Representative Scott?
Thank you, Mr. Chair. My question concerns lines 3.16 to 3.19, having to do with security data, and I don't know if this is something that Mr. Choi can answer, or perhaps Representative Holberg. I think you have Chapter 13 out there, but in regard to security data, and it says the location data maintained by law enforcement agencies and all these authorities can be shared. With security data, is there a protocol? Is there something that, is there a way of having, as we talked before on the previous bill, an audit trail to see who is looking at this information, or is it just open to anybody in those departments, whether it be court services or a prosecutorial, your county attorney's office? Just who all has access to that data, and do they have to have prior authorization so that not everybody in their respective agencies has access?
Mr. Choi?
Mr. Chair and Representative, I think one way to understand kind of what happens with respect to this GPS technology is that we have a private vendor who would be monitoring all of this, and then when there is, when the person with the ankle bracelet gets too close to the person who's being protected, I suppose you could understand it in a way that it's much like calling 911. That private vendor is going to make a call to law enforcement. That private vendor will contact the victim. The private vendor will contact the person with the ankle bracelet, giving them following whatever protocols that are in place. And then with that information, the appropriate people respond. And then once we get some more information, it could be used, I guess, for a potential violation of the no contact order. So that's typically how it would work in terms of the sharing. Now, with respect to an audit trail, I don't have the answer for you. I don't know if Mayor Pat would either, but it's something that we could probably get back to you on if we could try to figure out how if someone wanted to figure out who was actually looking at this information, we could try to figure that out for you.
Scott?
That would be great. I just don't want anybody in law enforcement or these other agencies kind of tracking people either. So, thank you.
Representative Johnson?
Mr. Chair, Representative Johnson, I understand the confusion with the names here. I've actually been involved in a case where we had 5 Johnsons and the suspect was a Johnson all at one time. In the last committee that this bill was at, I raised some concerns involving 2.33 to 3.4, dealing with each congressional district making up their policies and procedures. I brought my concerns up at that time about how in law enforcement, when these situations happen, it doesn't always happen at the person's home. They could be on vacation. They could live in, I will say, Lake County, and the offense happened in Rock County, about as far as part of the state as you can get. Down in the judicial district in Rock County, they might have different protocols and had the system put on. Both the victim and the suspect go back to where the jurisdiction they live in, up in Lake County, and they have different protocols, different situations, and they have an offense involving the protocol of the device down in Rock County, but it's not a violation up in Lake County because of the rules that they have. That's why I brought up the concern about having instead of each judicial district for the standards, it's a statewide standard. So everything's the same everywhere. Because it could cause some great concerns as people do travel, and unfortunately these horrible incidents happen all over the state and not just in the person's home.
Representative Johnson.
Mr. Chair and Representative Johnson. Couple of responses. First of all, fundamentally, these are state standards. The 6 standards that you see listed in the bill are minimum state standards. Secondly, there's inevitably a selection process about who shall be involved in this program. As Mr. Choi indicated, there are multiple possibilities for choosing who would be involved in the program, and I would expect that if the case was initiated and controlled in Rock County, and the judge and the prosecuting attorney knew that the defendant or the victim was going to move to Lake County, that they might choose not to offer this protocol or offer this situation in that case. You give a good example too, though, because the protocol that one would use in Lake County, especially with respect to distance and other thing, and really the geography, would necessarily be different than it would be in Rock County or in Ramsey County. And in the last hearing, I tried to stress 2 reasons why I think there's value in judicial districts controlling using the minimum state standards to develop the more specific standards for use in the judicial district. One being the varying geography of the state, and that can be both in terms of concentration of population, urban, rural, as well as geographical features such as in the Northwoods, GPS just doesn't work as well as it does in other parts of the state. The second reason, though, I also believe strongly in, and that is a matter of fundamental local control, and that this is sensitive stuff. And you notice I mentioned in my opening remarks the work that my area has had with the specialty courts. And really what we see in our use of specialty courts, drug courts and veterans court, the value of criminal justice professionals and the community working together to address significantly challenging situations. And we've had a lot of success with it. And I think it's not only with respect to that specific case, but in a larger context in creating a criminal justice system that is a little more adept at meeting challenging cases that we have not been successful with in other situations. So that would be my response to you, Representative Johnson.
Any other questions for Representative Johnson?
Mr. Chair, and this would be for the Ramsey County Attorney. The one question I have, and I actually do like the idea of this concept. I've been involved in many domestic situations, very bad ones, and understand the complications that arise out of them. One of the questions, can you tell me what the cost is to have this one person on this program?
Mr. Chair
Sure.
and Representative Johnson, We have utilized criminal forfeiture funds for this program, and since its inception in November of 2012, we have expended a little bit over $20,000 for about 27 individuals that were on this program. The way that we have the financing of this is that the first option, we ask that the accused pay for the technology. And if they have the means, then they do. If they do not, then we pay for the technology so that we can keep domestic violence victims safe in Ramsey County. So it varies. I mean, you could just do the math and say 27, and we spent a little bit over $20,000, but each individual case, there might have been more expenditure or less, depending on how much time it takes to resolve the case. But per monitoring day fee, right now our contract is $11 per day, and that's what it is.
Representative Scott.
Thank you, Mr. Chair. So if they're found not guilty, then do they get their money back?
Mr. Choi?
No, they do not.
Any other questions? Seeing none, then the chair has moved that House File 2295 as amended be re-referred to Committee on Judiciary, Finance, and Policy. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you, Representative Johnson. Thank you, Mr. Choi. Representative Moran. Representative Moran has House File 2373. There is one author's amendment A3. Oh, that's right. Okay, so members, the only reason this bill is in committee is because of lines 3.1 to 3.5 relating to data practice, subdivision 6. Because the A3 amendment does not affect those lines, that's right, we can't act on any because this is an informational hearing, so we can't act on the bill. So we'll act on it on Tuesday, but for now, if you can just explain the bill briefly, Representative Moran, and the point of why the data practices subdivision, which is why it's here.
Okay. Good afternoon, Mr. Chair and members, and thank you so much for having this informational hearing. And unfortunately, it's not a regular hearing, but again, thank you. So the purpose of House File 2373 is to begin correcting a gender earning gap in the Minnesota workforce and to improve the economic status of women. Minnesota women who are working full-time and year-round still earn only 80% of the earnings to their male counterpart. And that percentage in communities of color is even lower. And the gap is even larger, I should say, larger for women of color, rural women, and older women. Furthermore, the gap is not going away on its own because it has been stagnant for the last 10 years. We think this bill offers a first step in the process of ensuring that companies doing businesses with the state are paying women equally for the work of equal value. This bill offers a phase-in process and keep business data private. And it applies only to contracts for goods and services over $500,000 and businesses with more than 40 employees in the state of Minnesota. And I will stop there.
Thank you, Ms. Moran. You have a testifier.
I do.
Please introduce yourself for the record.
Mr. Chair, members of the committee, my name is Bonnie Watkins, and I am here today for the Pay Equity Coalition of Minnesota. I know that you're trying to move through at the speed of lightning, so I could answer questions about the technical side of the bill. I'm the person who wrote the administrative rule for the local government pay equity law, so I know some of the technical stuff. But my understanding is the data issues are your primary concern here. So just to reinforce what Representative Moran said, on page 3 of the bill, this data is held private data on individuals or non-public data, and that is exactly how the affirmative action certification process works now, so it really would not change that.
Representative Holberg.
Thank you, Mr. Chair. What data could what data would the commissioner be prohibited from collecting from businesses?
Ms. Watkins.
Mr. Chair, Representative Holberg, it might be easier for me to answer the other direction, what is submitted, and can I do that?
Representative
Mr.
Holberg.
Chair, in the matter of time, that's my point. I think your bill needs to delineate the data sets that the commissioner would have the authority to ask for. The way the bill is written right now, there is no constraint on what the Commissioner of Human Rights could ask a business to provide. So I think there's far more data issues here than just the page 3 classification of what they get. A much better bill would be for us as policymakers to sign off on the data sets that would be required for the businesses to provide. And as long as this isn't going to come before the committee till Tuesday, I think there might be time to accomplish that.
Thank you, and I think the chair generally agrees with your sentiments, Representative Holberg. Representative Moran, will you work on that between now and Tuesday?
Absolutely.
Thank you. Any other questions from members of the committee? Okay, there being no other questions, there being no motion before the committee, because it's not in our possession, thank you. And members, just so you know, on Tuesday, we will take a look at that question raised by Representative Holberg, but it's not our intent to look at any other aspects of that subdivision because we had the hearing today. So thank you, Representative Moran.
Thank you.
Wait, I'm sorry. We do have testimony, opposition testimony here on this. You can come down and introduce yourself for the record, and please limit your comments to subdivision 6, the data practice provision.
Thank you, Mr. Chairman, members. My name is Jill Larson. I'm with the Minnesota Business Partnership. And, Mr. Chairman, with respect to the data provisions, Representative Holberg did bring up some of the concerns that we have. But in addition to that, if you look at the other language in the bill, one of the requirements is that a business would have to prove that it had established equitable compensation relationships for its employees within the state. And it's not clear to us from the language in the bill as written how a business would actually do that. So that begs the question of what kinds of information would a business that wants to bid on a state contract, what would they have to submit to the department to prove that they have met this requirement of equitable compensation relationship, which is not a term that is used in the private sector. And also, the language on line 3.3 references private data. I know that there's another version floating around. It might be the Senate version that references confidential data. This version references non-public data on line 3.3. I've seen another version that says it's protected non-public data, and Mr. Chairman, I am by no means a data expert, but that those terms, and they're used interchangeably, are confusing to us and give us pause as to how we would know if we are actually complying with this. And finally, Representative Holberg brings up an issue of what kind of data would we have to give the commissioner, a salary spreadsheet of every salary of every employee, and what assurances are we going to have that proprietary information would not be somehow inadvertently released so that businesses' competitors might have access to it. So appreciate your listening. Thank you.
Thank you for your testimony, Ms. Larson. Representative Scott.
Thank you, Mr. Chair. And Ms. Larson, has the business community have they put any, I don't know if there's even any way to do this, to put any numbers to what collecting all this data and submitting it to the state is going to cost them in terms of manpower and fiscal numbers?
Mr. Chairman, Representative Scott, I don't have an exact number, but I do know from talking to our HR people that it would be a massive undertaking. Of course, we have I represent large employers, but this bill applies to anybody with 40 or more employees. We have sophisticated HR systems in place now, but what this bill as written would require is basically shoehorning in a compensation system that was developed for the public sector, and essentially shoehorning, or in some cases maybe almost replacing the current HR system that these private companies have. So it would be an extensive change, costly, and again, I don't want to get into things outside of the purview of the committee, but because we would have to make some changes, and it's only applying to Minnesota employees, it raises the legal question of what about the employees that aren't in Minnesota? We obviously have employees across the country, across the world. Would it also have to apply to those? And if it didn't, would we run into legal problems with one employee that's in Georgia, has a different job description or payment than what we would have to create to comply with this Minnesota law? So there are a lot of concerns with increased litigation as well as the regulatory costs in terms of complying with this.
Any other questions from members? Representative Newberger.
Thank you, Representative Moran. Just giving this the bird's eye look, how long would the commissioner be storing this data? And would they keep it for a year? Would they keep it for 10? Would they keep it in perpetuity? How long would they have this on file in their offices?
Representative Moran.
Mr. Chair, Representative, I don't have that answer, but it is clear to me now that I think it would be in our best interest to have the Department of Human Service also testify, so they can answer some of these questions.
And I'm guessing, Representative Newberger, that the whole point of it would be to have it indefinitely, so you could do longitudinal examination of this as well. I can't imagine they'd want it for limited duration, but I could be wrong.
Mr. Chair?
Representative Scott.
Thank you. Is there a fiscal note on this bill? I know that's not really our purview, but I guess I'll ask the author. Is there a fiscal note on this bill?
Representative Moran.
Representative, we have requested a fiscal. We have requested that.
Any other questions from members? Okay, thank you for your testimony, Ms. Larson. Is there any other individuals who wish to be heard on specifically subdivision 6 of this bill, data practices? Okay, thank you. Then this bill not even being in front of the committee, we're not doing anything. And we'll see you on Tuesday, Representative Moran. Representative Holberg. Representative Holberg moves House File 2120, Data Practices and Personal Data Privacy Legislative Commission created, that it be recommended to be re-referred to State Government Finance Committee. Representative Holberg.
Thank you, Mr. Chair and members. And this bill is just a little first step in trying to address a pervasive problem. From my perspective here in the legislature, technology and data use in our state and country, and in fact internationally, is moving at warp speed. And as I said in the previous committee, I believe the legislature is being run over by snails in comparison. And many of these issues are very complex. They involve competing interests, whether it's privacy versus public health, public safety, business interests versus government interests. And we, in my opinion, are doing a horrible job of keeping up. In addition, we lack expertise, and it's in large part a function of the time that it takes to understand some of these issues. And so in an attempt, very simple goal here is to develop more expertise in the legislature around these issues. I have before you a proposal modeled after the old pension commission before it was made larger, of 10 members of the legislature, 5 senators, 5 House members, 3 from the majority party, 2 from the minority party in each body, to be able to meet in the interim and off-season, to have hearings, to learn more and hopefully develop more expertise in the legislative body to make recommendations on issues around data privacy. Pretty simple goal as far as the funding part of that. We will deal with that in Chair Murphy's committee, but on a low end, we're looking at $8,000 from each caucus and a couple thousand from the LCC, up to, if you actually had a coordinator, you'd be looking at about $150,000 a year. So it's my intent to do it as cost effectively as possible. Probably will need more work for people like Mr. Gehring, but on the interim, et cetera. But quite frankly, some of these issues, you need the time to have the testimony, digest them, come back in a week or two or a month with a variety of proposals and weigh, again, the competing interests to have good public policy enacted. And I think Mr. Gemberling is here to testify on this bill. I'm not sure if anybody else is, but I'd be happy to stand for questions.
Question from members? Representative Liebling.
Thank you, Mr. Chair. And Representative Holberg, first of all, I want to just say again what everybody's said so many times, that your presence here will be tremendously missed because of your expertise on this really important issue. And I see what you're trying to do here is create somewhat of a continuation of that expertise, and I very much appreciate that. That said, I'm just not sure, I'm not opposed to doing this. I'm just not sure how well this is going to work. I think that what I see in this bill is kind of a lot of doing formally something that we usually do informally, because there's nobody in here besides legislators, and we create all kinds of task forces and work groups, and we get the staff to come and help us without putting it in law. Maybe what you're trying to do is, by formalizing it this way, is kind of try to make sure it happens, but we really need to replace you and maybe get somebody on the other side, on our side too, who really care to make this their area of expertise and dog this issue. I'm not sure, I'm not really speaking against the bill, but I just wonder, I guess my real concern is that, we legislators are all pulled in so many directions. And sometimes when I get appointed as a chair to another committee, this, that, to study, I'm like, oh my gosh, how am I going to do that? I have so many things to do. And I think what you want here is people who really want to take the time and make it their business to understand these issues, and that's a great goal. I'm just not sure that, I guess I'd like to hear what other people think. Are we going to really follow through? I hope we would, I really do, but I look at this and I think, oh, please don't appoint me to this. Only because, I could learn these issues, I could try, but I don't have the time, and I hope somebody does.
Representative Holberg.
And Mr. Chair and Representative Liebling, I hope that you're not appointed either, because I'm hoping that they can find 5 people in each body that have an interest in this. We need more than me. Even if I was coming back, we need more than me. The people that stalk me, the line up at my desk, the white slips that come in to the House floor, these policies need to have a variety of opinions and a balance. And when everybody just goes to one person, no matter who that is, that's not good public policy making. It's actually really bad public policy making. And it's something that I've been very uncomfortable with. And when I have tried to engage this body in very important issues and get more feedback and involvement, I have been disappointed. And I mean, like I said, my goal for this is very low. I just want more experts, because that's the way you get the good policy. I think of the old MJNO, the illegal police database, and the months and hours that were put in putting together the audit trail, the standards, how this could be a good database with accountability, and was so looking forward to the discussion by the legislature on whether this was the right way to go. And, the virtual, well, if that's what you want, fine. And I wanted the discussion. I wanted the discussion around where was that balancing or tipping point? Where is the range of possibilities? And it's frustrating. And I looked at a model like an LCCMR, where you might have the ACLU and the Newspaper Association, and certain states have whole privacy departments in which it's an executive level department in which there's a lot of attention paid to these issues. I was reviewing the state of California's website the other night on another issue, and they have a privacy compliance official for the public to interact with if they feel that their privacy rights have been violated. So there are all kinds of options and models, but until we have a handful of people in both bodies of both parties that can begin to bring the variety of options to the table and have the discussion and engage the right people, we will be continuing to be run over by snails.
Yeah, thank you. Thank you, Representative Holberg. And yeah, I'm interested in that you thought about all these different models, and as usual, you thought about a lot of different issues in this. And I just wonder if it wouldn't be more effective in keeping this going, rather than relying on hoping that some legislators will pick up an interest in it and find the time to kind of carve out this area of interest, which, I mean, I think none of us understates the importance of this area and the importance of understanding these issues, even though very few of us are able to devote the time to that. But I wonder if it wouldn't be a bit more effective to have some folks who are not legislators to kind of keep it going, to keep flagging the issues for legislators, to make sure that it isn't dependent on certain people who get pulled in a lot of different directions, but there's a body of some kind that keeps saying, think about these things. I know you've thought about some of that. It just strikes me that this isn't going to get us where we really need to go.
Representative Simon.
Thank you, Mr. Chair. I support the bill. I think it's an important idea and a good idea for at least a couple of reasons, which you touched on, Representative Holberg. One is the work in the interim. I've discovered, as chair of the Data Practices Subcommittee, that session really is not the time to do the sort of thoughtful view from 30,000 feet sort of work, because we're a bill factory during session. That's what we are. And so the Data Practices Subcommittee, by design, by the way, is meant as the place where we hear stuff that references Chapter 13. And it's often a very long list. We're not meeting this year, but in the last year when we met, it's a long list, and we're just processing it, and it's kind of a factory assembly floor, kind of factory floor operation. And there just isn't time to do that. So having some mechanism in the interim is number one. And number two, what makes this issue area unique, as you know, is it totally cuts across all sorts of jurisdictions. Yes, it is its own kind of area, data, government data, data privacy, making sure private stuff stays private, public stuff stays public, but it cuts across so many different areas, as we know from the Data Practices Subcommittee, where one day we'll hear, or one bill will be a transportation bill, the next one will be a Health and Human Services bill, the next one will be an environmental protection bill. Why? Because they all touch on that area. So yes, it's its own discrete area, but it also cuts across all other areas. So, and in terms of the structure, I appreciate Representative Liebling's comments. One of the problems, though, that always happens when you try to create a board or a commission that draws upon outside interests is you start playing favorites and naming. I'm always uncomfortable naming particular outside groups in statute. It happens once in a while, and sometimes you just can't avoid it. But naming a particular group is tough. I guess the other way we could do it, I suppose, if you wanted non-legislators, is just to say that the leaders of the four caucuses can appoint X number of legislators and X number of others, and then they, if they choose to turn to Minkoji and someone wants to appoint Mr. Gemberling, or someone wants to turn to the ACLU and appoint someone else, they can do that. That would be another way to do that, but I don't have a strong objection, at least starting out, to the way that you've done it. But I think some mechanism where there's a way for legislators or others to view these issues thoughtfully, not necessarily in the context of a bill, let alone one of 30 bills before you in a 2-hour, 3-hour hearing, I think that would be useful. So.
Well, and if I might, Mr. Chair, briefly, it also would do away with the problem of once we sine die, the committees are done. So you lose 6 out of every 24 months, even if you did use a subcommittee model. And as you know, if I think of what happened over the interim on data issues, you had the drones, the Kingfish, you had Minsher's marketing plan that went to a temporary classification 45 days before the state fair opened in order to get to the state fair without disclosure. I mean, all kinds of issues happen whether we're in session or not. And in a non-budget short session year, Representative Liebling, maybe as this group meets in the next 6 months, maybe they'll look for a more structured, involved standard in a budget year moving forward under a start of a governor's term, et cetera. I can't predict, but this is just trying to get more people with more expertise to get better results.
Representative Portman.
Thank you, Mr. Chair. I think it's a good idea. I think we should do it. The Legislative Commission construct is a good one because you don't have a bill in front of you. You have an opportunity to learn together. And on bigger issues that persist year in and year out, people have the opportunity to develop some expertise and some working relationships, which are just as important as the expertise. It does depend on members taking initiative, particularly the leadership, and it can't be effective if it doesn't have staff support and if it doesn't have a budget, because having a meeting with 10 members is, $1,500 just in per diem. So there'd have to be some sort of a budget in order for it to work.
Any other questions from members? Representative Scott.
Thank you, Mr. Chair. Well, I'm in support of this bill, and I often thought there should be a full data practices committee in addition to civil law, because so much of what comes through here is related to the keeping and what we do with data. And so I'm in support. I think it's a good first step, and I think it would be a good working commission in that we could have, our staff who are experts. We could have the experts come in and kind of educate us on a lot of things, and I think it'd be very valuable for the members of this commission to have those resources in the interim where we're not under the pressures of time to really take the time and learn. And I don't know if we even have people from the law school come over. I don't know what it is, but I think there's plenty of resources out that we could all benefit from.
Representative Holberg, I don't know how many members in the committee have served on the Pensions Commission. Have you served on the Pensions Commission? The unique thing about the Pensions Commission is it is fundamentally dollar-driven. So pension interests and proposals come forward for which we've just put together a pension bill, and then the legislature decides if it's going to fund it. The nuances of this and the duties that you have laid out, I think, make for more interesting, because we're not just looking at a bottom line issue. We're looking at making recommendations, and I'm assuming you mean prospective recommendations, not just on the proposals that are coming through committees, because then it would be the same thing as a data practices subcommittee, just run the bills through it. So would that be your intent, that this particular commission set parameters by which the various bills, like all the data practices bills that have come through this committee this year, would have to meet in order for them to be reliably considered by any committee? Or the reason I'm asking, as you can see, because we're talking about substantive language stuff, we're not just talking about Pensions Commission, which is bottom line, do you have the money or don't you?
Well, I guess I think it's largely going to be driven by the people that are appointed to it, how far they want to take it. I mean, if there's a particular agency that's engaging in a particular behavior, and there's 10 members of the legislature that think it's the wrong direction, and they want to pass a resolution conveying that position, they could. I don't view that they would necessarily put together an omnibus data practices bill. Again, the focus for me is more educating and putting sunshine on issues, so that when you get to the legislative session, you have more than 10 minutes or a half hour. I mean, time and time again, we have seen bills leave this committee, and it's not just under your leadership, it's on many civil law chairs' leadership. Well, we'll fix that between now and the floor. We'll work with this before it gets to the next committee. If you have 10 people that begin to have expertise and ability and start learning kind of the standards and the constructs of how this works, I think you're going to have better bills coming to the table to begin with. But I don't view that this group would be given or take any power or authority away from a civil law chair or structure of the judiciary in the Senate.
Any other questions for Representative Holberg? Seeing none, then, is there any members of the public who'd like to testify on this? Mr. Gavel, please take a seat, introduce yourself for the record, and begin your testimony.
Thank you, Chairman Lesh. In your packet is written testimony from Matt Ailing, my colleague at the Minnesota Coalition of Government Information, which is why I'm here. I'm going to try and be brief. In the 34 years I worked for the state, I managed or wrote probably 8 different studies at legislative direction, staffed 5 different committees or commissions, watched a couple, 3 of them, and this is in response to Representative Liebing's question. The one difference at the end of all of it was if you had legislative involvement in any of those efforts as they went along, then more came out of it. Okay? If you didn't have legislative involvement, then you got another study, which I may have thought was a brilliant piece of work, and it got filed. I told Representative Holberg the other day, you know, we studied the bulk sale issue in the Department of Administration. It's sitting up in the Legislative Reference Library. We got kudos on that study from everybody, and none of the recommendations we made were ever put into law. Okay? So, and again, the difference is legislative involvement all along, frankly, means you invest. Okay? And so when Representative Holberg put this bill in, and she and I really differ on things of this nature, but I said, you know, this is the greatest thing that's ever going to happen in this area. And she said, no, it's just a baby step. And I said, well, yeah, but, you know, the legislature will finally acknowledge how important this stuff is. Okay? You know, I'm getting old. I have to tell you that. I usually don't describe myself that way, but I've seen all of this change. Okay? And I think a lot of people don't understand how much our lives have changed because of technology. Okay? But we're all kind of like sitting back and saying, oh, I can't handle this. Well, this is an opportunity, I'd like to think, that we can get maybe not ahead of the curve, but more even with the curve, because you take the time to talk about things and to think about them. And I think, you know, there's the opportunity to draw expertise from the community. What I've always been used for by people like Representative Holberg is to tutor and to say, okay, I understand what you're doing here, but think about blah, blah, and blah, blah. And I'm a frustrated teacher. That's what I was going to do when I grew up, and it didn't work out that way. I went to the terrible place of being a lawyer. So, but there are people available to help you do that. Okay? You know, I've always enjoyed my role as your institutional memory, but I ain't going to be here forever. So you need to replace that internally, okay, with your own expertise. Okay? Now let me give you one example of a thing that this commission might be able to focus on. We've all heard all this discussion about data breaches. Okay? One of my objectives when I was in admin was to help you develop legislation, hopefully that's kind of consistent on issues, which I think is a decent objective. But what do we all carry in our pockets? Almost all of us, if you drive. You carry a driver's license. Can you all tell me what's on the back of this driver's license? A mag strip. Okay? What's on the mag strip?
We don't know.
I know.
Exactly. We don't know. So you've said in statute the information on this thing is private. Okay? Except you've also said, because the federal government put its heavy thumb into the mix a few years ago, that private information has to be given to all kinds of businesses. Okay? So this is my private information, but it be given to all kinds of businesses. But also increasingly, what happens to you when you go into a store? They scan this, okay? What are they scanning? I had a situation a while back where I went into a municipal liquor store, and they wouldn't sell me hooch unless I let them scan this driver's license. And they told me that that was required by state law, which I know is not correct. So the consistency of how you deal with this stuff, I think could be much improved by what a commission could do, okay? And, you know, pretty soon, these are going to turn into chip cards. As a matter of fact, the enhanced driver's license that's being offered by the Department of Public Safety is a chip card. And it has an RFID in it, radio frequency identification device. Do I have some sense of what RFIDs do? Yeah. Am I going to know that an RFID can actually transmit information on my location? I don't know. So, but somebody needs to look at those things, and I think given the current tide on privacy in Minnesota, what Representative Holberg is doing here long-term will be much appreciated. So MinCoG really supports this. We support it from a transparency standpoint, and we support it as good public policy. And if you have any questions, I'd be happy to answer them.
Representative Liebling.
Thanks, Mr. Chair, and thank you very much for that. I think we're all pretty much in agreement on the need here. And Mr. Chair, it occurred to me we've got some folks from the Department of Transportation here, I think, or from the Department of Public Safety, I guess. I'd kind of like to know what's on the back of my driver's license. I think you could get them down here and ask them.
Let's ask them when they come to testify on the next bill, Representative Liebling. I'd kind of like to get through this. You want to come and tell us now? Okay. Please introduce yourself.
Just so you know, it's against the law to mar the magnetic strip, so it can't be read. I found that out.
Mr. Chair and members of the committee, for the record, Pat McCormick with Driver and Vehicle Services. The mag stripe has the information that's on the front of the card so that you have that available and can pull up the driving record for law enforcement. The RFID chip is a random number that's put together so that when you get to the border crossing, you have to show if you're crossing using that as a card. The Border Patrol has a database of all the driver's license numbers, and it pulls up and shows that you have the authority to have an enhanced driver's license. So that's what it has no other information, just this random number that ties to your driver's license so that it shows you are an authentic driver from Minnesota.
Ms. McCormick, is any of the data contained thereon in any way a prerequisite for buying hooch? It's not. Okay.
No.
Thank you. Any other questions? Seeing none, then is there anyone else in the audience who wishes to be heard on this? Then Representative Holberg has moved that this bill be referred to State Government Finance. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you.
Mr. Chair.
Representative Holberg's House File 2795 is taken from the table, and Representative Holberg moves that it be re-referred to Transportation Finance. Representative Holberg.
Mr. Chair, I'm not familiar. I don't have the minutes of the last meeting with us. I don't know if we ever adopted the 847 amendment. It's in our packet.
Why don't you, well,
It should be reflected in the minutes from, and I don't know if those were approved at the beginning of the meeting and they're in our stack somewhere, or...
if we just adopt it again, is that a problem, Mr. Geary? Okay, the 847 amendment is moved by Representative Holberg in order to get the bill in the shape the author desires. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Go ahead, Representative
All
Holberg.
right, and then I don't really even want to remind you of the hearing that we had the other day, but I guess it's necessary. It was not very fun, and I was able to take some time with Laura Bayer-Kapinski from iPad and kind of go back and kind of figure out how we got to where we were on Wednesday and how we could get ourselves back out of the mess. And so what I'd like to do at this point with, and I've talked to the chair about this, with an oral amendment, delete Section 3 of the bill, which is the study. I don't think we really need to study it. It's going to draw a big, juicy fiscal note and continue to irritate people that are already kind of irritated. So, and then let me just explain to the committee kind of where we would go next with this issue. I believe that the intent always was that the commissioner have the ability to sell bulk data under the federal permissible uses. And so the remaining part of the bill would put comfort language and make it clear that the Commissioner of Public Safety had the right to sell data in bulk. In my discussions with Ms. Byer-Kopinski, it became pretty clear that this really wasn't a Chapter 13 issue, but really more a Chapter 168 issue, in that driver vehicle services is a completely fee-based department in which we prescribe the fees, duties, and rights and responsibilities, et cetera, in their chapter. And so what we'd like to do is delete the study language, move this bill to Transportation Finance. In the interim week or so, work with the department to look at what they're charging currently, how it's addressing their costs of administering the program, whether there's a need to have a tiered fee schedule. The occasional tow truck driver may not be interested in the same fee schedule as an Experian or a Thomson Reuters might need, and set in statute their fee schedule. The only outstanding issue around this is the issue around auditing the use of the data. I personally am adamantly opposed to the department auditing their database, because we have this really weird situation where they contribute to it. They supervise the vast majority of the public sector users of the database in law enforcement, BCA, et cetera, and then they sell it to the private sector uses. So I want to have a conversation with State Auditor Nobles for some suggestions, look at what other states do, whether or not we can recommend an audit program using an independent source to audit the whole database issue. Whether we can resolve that in a short session, I'm not sure, but we can at least kind of stop the fight on the money and the business model for sure in the next week or so with this bill, and then start having discussions around the audit piece. So if there's any questions or anybody wants to comment, that's kind of what's transpired in the last 2 days around this bill.
Any questions before we hear from testifiers? Okay, if you were here to testify on this committee on this bill, please come down and introduce yourself for the record. Wow, peace in the valley.
Whoa! That's, Mr. Chair, that's the advantage of being up at 2:23 on Friday, as opposed to 9 a.m. on Wednesday.
Bless America. Okay. Well, then, Representative Liebling.
Yeah, thanks, Mr. Chair. I just want to be clear. Does that mean there is peace in the valley on this?
Well, that's not my sense, Representative Liebling. However, there is a hope for peace, I guess, right? Am I saying that correctly? Okay. Which is, close enough for government work, I guess. That being said, then, Representative Holberg moves to re-refer House File.
Mr. Chair, we have to vote on the oral amendment to delete Section
That's right,
3.
the oral amendment, the 847 amendment. What, didn't we just vote on it? Oh, deleting Section 3. So Representative Holberg moves to delete, can I just say Section 3 or I have to say the lines? Delete Section 3. All in favor signify by saying aye.
Aye.
All opposed say no. Motion passes. Now, all in favor of House File 2795 as amended, that it be re-referred to Transportation Finance, signify by saying aye. Aye. All opposed say no. Motion passes. Thank you, Representative Holberg. Good work on this, and I want to convey my accolades to the individuals who worked hard on this as well, and we expect you will continue to work hard to reach a resolution. Members, there being no other business before committee, I would note that our next committee is Tuesday, March 18th at 8:15 a.m. in the basement of the SOB. The committee is adjourned.